1994 to 2005 Grassroots campaign to win the Accessibility for Ontarians with Disabilities Act. David Lepofsky, Chair, Accessibility for Ontarians with Disabilities Act Alliance. Delivered at the Osgoode Hall Law School, January 14, 2014, as a Roy McMurtry Clinical Fellow.
Well, good afternoon, everybody. It's really a privilege and an honor to be able to speak to the introductory course at the York University Critical Disabilities Studies program. It's fabulous that you've chosen this as your area of academic study. Let me try to offer you some ideas that may help you think through challenging issues that face people with disabilities, not just in the area of accessibility, but well beyond. I have to indicate at the outset that I'm speaking in my personal capacity. I'm not speaking on behalf of the government of the province of Ontario. About 20 years ago, this November, 20 people, I was one of them, happened to end up in a room together at Queen's Park. Entering that room, we were angry. Leaving that room, we were the birth of a brand new movement. It was a movement that fought tenaciously with little or no money, little or no experience, but a lot of energy for 10 years. And it resulted in the enactment of two laws, the Ontarians with Disabilities Act 2001 and the later Accessibility for Ontarians with Disabilities Act 2005. When we started, we didn't have the slightest idea what we were doing, what we wanted, or how to get it. And we had no realistic hope of success. I want to spend my time together with you now telling you the story, the unfolding narrative of how we got from that room in 1994, on the 29th of November, all the way up to May 2005, May 10th, 2005, when we celebrated the achievement of a dream that we couldn't have believed possible when we started. As I go through, I'm not going to spend a lot of time on the detailed and more complicated policy issues that we were dealing with. I'm only going to touch on those in other lectures in the series that I'm going to be delivering this month and that I hope to get posted on YouTube together. I'll deal more with the details of public policy. What I want to do with you today is to talk about how we did it and what we learned as we went along the way. I want you to know that as we learned, we came up with ideas and strategies which were not only successful then, but which we continue to use to this very day in 2014 to try to get those two laws effectively implemented. Before I start with that blustery fall day in November 1994, however, I got to take you back to the 1970s, just for a couple of minutes. Back in the 1970s, people with disabilities in the province of Ontario or across Canada, as they do now, found that they were disproportionately unemployed or underemployed, disproportionately poor, disproportionately underrepresented among those who graduated from colleges or universities, disproportionately overrepresented among those who collect social assistance. They were poor, they were weak, they were disempowered. They faced barriers everywhere they went when they tried to get a job or an education or buy goods or services or to just enjoy the things that others take for granted in life. And in the 1970s, they were not organized. There was no aggressive, publicly recognized cross-disability advocacy movement to try to get this changed. Moreover, most folks with disabilities didn't even have advocacy or lobbying on their minds. Just getting by was enough of a challenge. We also didn't have the advantage of things like email, the internet, fax machines, smartphones, Twitter, Facebook, or other social media. We didn't even if you wanted to write a letter, you had to type it on a thing called a typewriter, and if you wanted to send it separately addressed to different members of the legislature or parliament, you had to type it over and over and over again. And by the way, if you made a mistake, you either had to use this weird stuff called whiteout or just start from scratch. And then you put it in the mail and waited a couple of days for it to arrive, and then waited days more to see if anybody responded. Things were very, very different. There were no telephone conference calls or video conferencing or Skyping for meetings. You had to actually get in the same room, in the same city, at the same time. And folks with disabilities across a province like Ontario, most part didn't have the capacity to do that. Cost a lot, took time, and they were poor and disadvantaged disproportionately. Despite all of these hurdles, people with disabilities fought two really important battles in the late 1970s and the early 1980s that are the underpinnings of the Disability Act movement of the 90s and the 2000s. I had the privilege of being part of all of that, one of many people that worked on what I'm going to describe. What we learned in the 70s helped dramatically influence what we did from 1994 onward. Back in the 70s, it was not illegal to discriminate because of disability. We didn't have a Charter of Rights to set out constitutional rights to equality. Our human rights codes, the laws that make it illegal for public or private sector employers and others not to discriminate, they banned discrimination on grounds like religion, age, race, and sex, but not disability. It was only in the late 1970s that some human rights codes in some provinces were amended to include disability, but not Ontario. In 1976, the Ontario Human Rights Commission recommended that the Ontario Human Rights Code be amended to include a ban on discrimination based on physical disability, didn't even mention mental disability. But the Ontario government took a leisurely 3 years to study that and related recommendations without action. Things changed in late 1979, and events unfolded that changed the legal landscape dramatically. Was there a groundswell of people with disabilities going to Queen's Park demanding that the Human Rights Code be amended to give them the right to equality? No, there wasn't. Was there a groundswell to pressure the federal government to come up with a new constitution that included equality for people with disabilities? No, it didn't. There wasn't. The issues actually arose, it was government action that brought us together. Two things happened in tandem. First, in the late 1979, the Ontario government, the Minister of Labor, wonderful man, just died earlier this last year, named Dr. Robert Elgee, came forward with a proposal, a proposed new bill. It was not an amendment to the Human Rights Code. It was proposed to be a separate law called the Handicap Rights Act, and it provided all the rights that the Human Rights Code would provide, though to people with disabilities, and it provided for the Human Rights Commission to enforce it. But it didn't actually open up and amend the Human Rights Code. The introduction of that bill triggered the formation of a human rights disability coalition. I eventually got involved in it and later was one of many who took part in the kind of leadership committee for that coalition. Of interest, the thing that brought people with disabilities together over that bill was not the fact that its provision of anti-discrimination protection of people with disabilities was actually weaker than what the Human Rights Code gave women, racialized communities, and so on. That wasn't the thing that got under everybody's skin. Interestingly, and in retrospect, ironically, what really got people angry was that this bill didn't amend the Human Rights Code. It didn't put disability into the Human Rights Code. It didn't make us part of the mainstream of human rights, and instead, it was going to provide for people with disabilities through a completely separate law. That was appalling. Fast forward 20 years, and we became a movement fighting for exactly that, a separate law. After action, which predated my personal involvement in late '79, by the disability community, the Ontario government, then under Conservative Premier William Davis and Labour Minister Robert Elgee, with significant support from then Attorney General Roy McMurtry, after whom my fellowship is named, the Ontario government decided to withdraw that bill and to come forward instead with amendments to the Human Rights Code that would protect against discrimination based on disability. I can tell you from being personally involved, it was a very exciting time because we formed our coalition, formed a platform, sat down across the table from Dr. Robert Elgee, the Labour Minister, negotiated clause by clause the amendments that ended up in the Ontario Human Rights Code. They were eventually passed in 1981 and proclaimed in force in 1982. It was very exciting. One of the things we learned back then is that it's not good enough to just talk about, please give us human rights. The devil is in the details. And when I was just finished my law studies, hadn't even become a lawyer yet, one of the things I learned early on is if you want to fight for legislative rights, you got to get very much into the very minute details of how the legislation is worded. Or else you could end up with the government smiling, saying they gave you what you wanted, but finding out that it was far weaker than what you thought you needed. At the same time as all of this was going on, the successful battle to get disability into the Ontario Human Rights Code, in October of 1980, our then Liberal Prime Minister, Pierre Trudeau, proposed amending our Constitution and including it in a Charter of Rights. The Charter of Rights would have an equality provision, Section 15, that would ban discrimination on grounds like race, religion, sex, age, and so on, but it did not include disability. At the same time as we were fighting to get into the Ontario Human Rights Code, a number of us got involved fighting to get into the Charter of Rights as well. Time doesn't permit me in this lecture to get into the details of that story, but I had the privilege of being one of the number of people who got to appear before a parliamentary committee in Ottawa in the fall of 1980. Those hearings were the first televised public hearings in the history of our parliament, and my presentation on December 12th, 1980 is now available on YouTube. Footnote, I had hair back then. Second footnote, don't remind me of that. Ultimately, through the pressure of people with disabilities around the country, without the benefit of email or faxes or social media or any of that sort of thing, the government was persuaded to amend Section 15 before it passed the Charter of Rights to include protection against discrimination based on physical or mental disability. Canada's was the first Western constitution to include an explicit guarantee of equality for people with disabilities. It went into force in April, the Charter went into force in April of 1982, though the equality provision didn't kick in for 3 years. Yet another really exciting victory. The difference between the fight to get into Human Rights Code in Ontario and the fight to get in the Charter in Ottawa was that in Ontario, the introduction of that handicap rights Act triggered the formation of a coalition of folks with disabilities. In the case of the Charter of Rights, no coalition formed. What instead happened was different individuals and different organizations went to Ottawa to press the case to amend the Charter to include equality for people with disabilities. By the way, in the entire 1980 to 1982 debates over our Constitution, the only new right that was added to the Charter of Rights in that entire debate was equality for people with disabilities. So where were we at in 1982? We were pretty excited. Won these two major battles, very much against the odds. Great rights, they're on the books. We got what we wanted and what we needed. We were quite excited. Now let's fast forward to November of 1994. Why did 20 people go into a room at Queen's Park wanting new disability rights legislation? Hadn't we won enough? Well, what we had learned over the years between 1982 and 1994 was that good rights on the books don't necessarily translate into actual changes in the lives of people with disabilities in their communities around our province or our country. Many people, I was one of many, had been involved in writing articles, giving speeches, doing training. Others, not me, were involved in arguing important court cases and so on. But what we found after the 12 years was that while we'd made some gains, we were still not anywhere near our goal of being full equals in society. And as quickly as we overcame some barriers, new ones popped up. This led a small group of folks with disabilities, not organized in any sort of comprehensive way, to decide that we needed something new. We needed something more. Not that the rights we had were inadequate as written. The Charter and the Human Rights Code were well drafted. The problem wasn't that the courts weren't effectively interpreting them. We had great court decisions explaining what they meant that were very favorable to the needs of people with disabilities. But what we found was that most government and private sector organizations weren't obeying them. And to enforce your human rights under the Human Rights Code or under the Charter of Rights, you had to litigate them, you had to get a lawyer and fight them. Case of human rights at the Human Rights Commission and Tribunal. And in the case of the Charter, by the way, the Human Rights Commission, you didn't necessarily need a lawyer, but in the case of the Charter, you did, realistically, in court. And you had to fight one barrier at a time. And most people with disabilities couldn't take that on. The other problem that we realized that we had back in the fall of 1994 is that while the Charter and the Human Rights Code were good laws, they didn't actually tell organizations what they had to do. They spoke in grand terms: provide equality, don't discriminate, do accommodate. But if you ran a restaurant, that didn't tell you need to have a Braille menu. Or if you had a store with one step to get in, it didn't tell you, hey, that one step, that's a barrier that violates the Human Rights Code. We faced all sorts of barriers that were against the law, but organizations that wanted to obey the law didn't know what they had to do. And organizations that didn't want to obey the law didn't realistically have to face proceedings to enforce them in most cases because of the extraordinary burden of having to fight these barriers one at a time. So that's what motivated a small number of people in the fall of 1994 to want something new, want something better. A new law, not to replace the Charter and the Human Rights Code and their guarantees for people with disabilities, but instead a new law that would effectively implement those rights, that would tell organizations what they got to do, and that would not require us to individually, personally fight one barrier at a time in court or before a human rights tribunal. Now, while this small group of individuals were thinking about this in the summer and fall of 1994, there was no organized Disability Act movement to push for it. Moreover, if you had approached anybody, in the media, they wouldn't have the slightest idea. Or if you talked about leaders in the business community, none of them would have any idea that there was even a problem, much less that some people were thinking of a new solution. So what got the movement started? What got the organized movement started on November 29th, 1994? Well, it's an amazing story. A number of people had asked the Ontario government of the day, it was a new Democratic government under the then new Democratic Premier Bob Rae, to bring in this new kind of law that we were seeking. The name of the law, we called it the Ontarians with Disabilities Act. That name came from the fact that in 1990, the US had passed the Americans with Disabilities Act, so we borrowed the name. And Bob Rae wasn't prepared to introduce that bill. He was a year away from an election, he didn't want to take it on, whatever. So what happened is there happened to be a deaf individual who was a member of the Ontario legislature named Gary Lepofsky, and he was a New Democrat. He was not in cabinet, he was a backbencher. And Gary decided, getting feedback from, and by the way, Gary was the first deaf member of any legislature in the Western world. He really made history. He decided to introduce his own private member's bill. That's a proposed piece of legislation, but not sponsored by the government. And he called it the Ontarians with Disabilities Act. He introduced it early, I think in the spring or summer of 1994. And it was not the organized disability community that led to the bill. It was rather the bill that triggered the formation of a Disability Act coalition. Just like what happened in 1979 when the Bill Davis conservative government introduced proposed new Disability Act legislation. That triggered the formation of a coalition. Then, in 1994, the Lepofsky bill triggered the formation of a coalition some 15 years later. How did it happen? I'm summarizing because of time limitations. If you read the article, which I've had published on the first 8 years of our movement in the National Journal of Constitutional Law, you can get more details. But in summary, what happened was, once the bill got before the legislature, Gary Lepofsky's bill, the government doesn't necessarily bring it all the way forward for a final vote. So a number of us privately pressured the government to at least bring that bill on for public hearings. Get it before a standing committee of the legislature. Let us come forward and make our case for why we need the bill. Premier Bob Rae and his government decided to do that, and the hearings started on November 29th, 1994. And they didn't start with us making presentations, but instead they started with the cabinet minister in the Rae government responsible for this area, Elaine Ziemba. She got up and made a speech. And her speech didn't really talk about Gary Lepofsky's bill and didn't really answer the claim of why we need this legislation. It was just kind of fluff. All sorts of nice things about Gary Lepofsky and about what a great guy he is, and of course the usual, what a great job the government's doing, or whatever. But no content on the subject that we were there. And there were a number of people in the room, 20 of us from various aspects of the disability community, who heard that the hearings were going to begin, and we wanted to be there to see what happened. So our blood pressure was boiling, was going up pretty fast as this speech droned on. Then the hearings adjourned, and word got out around the room, around us as we were leaving the room, to come down the hall. I think Gary was the one who got this to happen. But everybody said, like, go down the hall. People are meeting in room whatever at Queen's Park. There was some empty committee room. We went in. And it was in that room, 20 of us, angry at what we had just seen going on before the legislative committee, resolved ourselves to form a coalition to fight for a Disabilities Act. That's how it started. I had no idea walking in that room that we would walk out with a new coalition. I had no idea that a month later I would become a co-chair and later chair of the coalition, and that it would gobble up a substantial part of the next 20 years of my volunteer life. I'm delighted it has. It's been a wonderful experience. But sometimes the most amazing events and the most amazing cascading series of events start with things that you can't imagine, or you can't imagine where they will lead you, I should say. So, how do we go from 20 people in a room to two pieces of legislation 10 years later? Let me walk you through just a number, in summary form, a number of the important steps, how we did it and what happened. The first thing that we had to do in early 1995 is to formalize ourselves, give ourselves a name, the Ontarians with Disabilities Act Committee. We at first were 3 co-chairs, but eventually it boiled down to me after the other 2, who are good friends, decided that they didn't want to carry on in that role. And we had to set out an agenda. What do we want? Well, what we did in January of 1995 was to bring a bunch of people together in a room, and we drafted a list of our principles. There are 11 of them. And they were aimed at saying essentially what we want in the legislation. We said we want the legislation to achieve a barrier-free Ontario. We said we want accessibility standards passed to get us there, that we want effective enforcement, and that it's got to cover the public and private sector, goods, services, employment, and so on. And that it had to be meaningful and effectively enforced. And when we wrote those 11 principles, we had a few guiding thoughts in mind which carried us to this very day. The first is that we've got to speak to all people regardless of their disability. We've got to unite our community around these principles. The second thing that we realized as we were writing them is that they've got to set out a clear vision of where we want to go. The third is we want them to appeal to everyone. We want to write them in a way so that anybody reading them, whether people with disabilities, politicians, journalists, whoever, that they would simply say, well, of course you should have that. So while ambitious, we didn't want to be controversial. We wanted to appeal to as many people as we could. And we were an unusual coalition from the start, because in the past, any disability advocacy groups in our community, almost any, I shouldn't say any, but most of them were either united to speak for one disability group or a cross-disability group or whatever, but they were broad organizations that addressed all issues. We decided we would only deal with one issue, and that is the fight for a Disability Act. Now, from formulating those 11 principles, which, by the way, still remain our guiding principles almost 20 years later, what did we do next? Well, we had to pull together at least a base of operations in Toronto. We were very Toronto-centered at this point. We reached out to some of the main disability agency, the service providers. We reached out to a small number of individuals. We just wanted a starting critical mass to get started. And we learned a lesson early on, once we got our 11 principles written, that has also guided us to this very day. What we decided were 2 things. First, we decided that we were open to work together with anybody who agreed with our agenda, and if you didn't agree with our agenda, we weren't going to fight with you. So there are some folks with disabilities who thought the idea of a Disability Act was a good idea. We would join up with them. There were other people who thought it was a bad idea. And we said, fine, it's a democracy. You're entitled to believe what you want, but we're not going to spend our time arguing with you. We're happy to share our ideas. We're happy to learn about your concerns. But life's too short. We're just going to keep trying to unite people who agree with our message. And that has worked to this day, because one of the things if you think about it, it's not possible to get every single person with a disability to agree on anything. People have differing views. So our goal was to come up with an agenda that would appeal to enough people and get enough people on board, recognizing we would not get everybody. Unanimity is not possible. Harmony is. And that's what we fought for from day one, or strove for. I said there were two organizing principles from the outset. That was one. The other organizing principle that it carried us through was this. Any advocacy, community organizing effort is, by definition, daunting if not overwhelming. So we found that to keep things moving, we would try from time to time to just set goals for the next couple of months. Focus everybody on those goals, get through them, and then when we're finished, sit down and go, all right, what's next? Let's just get through the next couple of months. Well, in February of 1995, what was our major goal? Well, it was easy. Once we got people together, enough people together to at least have a critical mass to get started. By enough people, I mean a couple dozen, a few dozen, and a few disability agencies. Our next priority was set by external circumstances. There was going to be an election that spring. We all knew it. So our priority was to raise the Disability Act issue in the election and to try to get commitments from the political parties. How did we do it? Well, at the time, the Bob Rae NDP government was way behind in the polls. And the Liberal Party, under the then leader Lynn MacLeod, was way ahead in the polls. And the third party in the legislature, the Conservatives, under a new leader named Mike Harris, nobody was paying much attention to. So we decided to focus, even though we were nonpartisan, we focused our efforts on trying to get an election commitment out of the Liberals. And so we negotiated with some of Lynn MacLeod's senior policy people behind closed doors. And when the election, around the time the election was called that spring, Lynn MacLeod wrote us a letter. She was the first political leader to write a letter to the Ontarians with Disabilities Act Committee, promising that if elected, she would pass an Ontarians with Disabilities Act. Now, we didn't even say what it would include. We hadn't gotten that far yet. What do you do with that? Well, that was great breakthrough, but you don't stop there. So we took her letter and sent it on to the two other folks running for premier, Mike Harris, Conservatives, and Bob Rae, NDP. Bob Rae would not make a commitment to us. He wasn't making any commitments. It was the weirdest political campaign I've ever seen. A lot of respect for Bob Rae, but how he handled that one we never quite fathomed. But on the 24th of May, 1995, in the middle of this election campaign, we received a letter from Mike Harris, running as the leader of the Conservatives, also promising that if elected, our Mike Harris government would also pass the Disabilities Act and that they would work with us to develop it. Mike Harris saw the Liberals, no doubt, as their lead opponent, leading in the polls, wanted to be more appealing, so tried to match the promise that we got from the Liberals. Well, the rest of that election's history. The Liberals plummeted, Mike Harris won a majority government, and we went into the next phase of our activity, starting in June of 1995, election over, with this election commitment in hand from the new premier. But before I get to that, I want to just tell you one little story about what went on during that election, because it's a really good illustration of how we did what we did. And this repeats itself over the decade over and over and over again. During the election campaign in 1995, nobody had ever heard of us. Most people with disabilities, most disability organizations, most politicians, all journalists, no idea what a Disabilities Act, what the issues were. And during an election, if you try to raise an issue that people don't know about, good luck getting coverage. So we decided we wanted to do something to get some media attention during that election. One of my colleagues sitting around the table one day, this is when we had a working group of about 8 or 9 people, nothing more. There are more people in this room right now than we had doing our political strategy. One of my colleagues, wonderful fellow, said, "Why don't we go to an all-candidates debate and raise these issues?" Well, the response is, the media don't cover all-candidates debates. So the same individual spoke and said, what if it's an inaccessible all-candidates debate? Brilliant idea. So we had a couple of our colleagues start phoning around to every single all-candidates debate that was being advertised, find out where it was, and ask if it was wheelchair accessible. If it was, we were pissed. We can't go there, can't make our point. Finally, bingo, we found one at a school down in the beaches that was inaccessible. So once we heard that, I said, well, we better make sure it really is inaccessible before we make a stink about this. So we had somebody drive by and go in, and yes, absolutely, there are stairs. There is no way to get in there without going upstairs. So we arranged folks to go there. We gave word to the media that we were going to go there to that all-candidates debate that night with folks with in wheelchairs and others to raise an issue about the inaccessibility of their event. What a great way to show why you need new accessibility laws. In fact, we said we want to complain about inaccessible schools, but we can't go to your inaccessible school where you're holding the all-candidates debate to complain about it because it's inaccessible. And the media love photographs, they love pictures, so off we go to this event. Well, one of the things we learned early on is that, as well, is that things never unfold as you plan, and sometimes they unfold way better. We get to this event, and we are outside. There's about a dozen of us, I think, I don't know, 4 or 5 people in wheelchairs, a few people who could walk. I don't even remember all of whom, but we were a small group. And we're outside, everybody else is streaming in. And we couldn't get, I shouldn't mention names, but the initials are 680 News to come to cover it. So I phoned the story in and they put me on the air. I'm standing in front of this suburban schoolhouse. There are people with disabilities, they can't get in. They put it on the air. You can't get the reporters to come to you? Become the reporter. So, that alone would be a great story, but it gets better. One member of our group, without consulting with any of us, I don't even remember who it was, went inside, this is someone who could walk, went upstairs to the all-candidates debate, and shamed the politicians. What are you doing up here? There are people with disabilities that can't come in. Why don't you come downstairs? So the politicians came down, TV cameras are running, and they talked to us outside. Out comes my cell phone, back on 680 News, breaking developments. They put it on the air. After the politicians, entirely embarrassed, finished talking to us, they said they got to go back in. Somebody from my group, again, none of this was rehearsed, said, you can't go back in and leave us out here. Meanwhile, while we were talking out front, some of the individuals at the all-candidates debate upstairs got bored waiting. So they came downstairs to outside the building where we were standing or sitting. Then the organizers ran in and started bringing out chairs. And next thing you know, the rest of the all-candidates debate was held outside on the sidewalk in front of the inaccessible school. So what does Lepofsky do? Out comes the cell phone. More late-breaking developments. We were on radio, we were on TV, and we were in the newspapers the next day. There was maybe 12 of us on an issue, fighting for a Disability Act, that nobody knew anything about. This was a huge lesson about the ability to make a difference and to make it up as you go along. So, what do? The election's over. We've got this letter in hand from Mike Harris promising us a Disabilities Act, and Premier Harris said that he would keep all his promises or he would resign. So we had to get to work. And we're nonpartisan, we'll work with anyone, but people understandably were skeptical of whether he would keep this commitment because his government was committed to deregulating business, and they didn't think they were going to be too willing to pass a law that would add any obligations or requirements on business. So we tried to organize, tried to get meetings with the cabinet minister responsible for this area or with the premier. Nobody would meet us. So new strategy kicks in early 1996. We decided to go to Queen's Park to bring people with disabilities with us and to get an opposition member of the legislature to introduce a resolution to be voted on in the legislature. Now, resolutions in the legislature are not legally binding. Nobody has to do anything. But it became a great focus for activity. This is yet another illustration of our early strategy that's become our always strategy of focus people on a narrow range of activities within our community so that they can all try to work together rather than getting sidetracked and divided into a million different things that all peter out. So, what do you put in this resolution? Well, one idea was, why don't we put in a condemnation of the government, whereas Mike Harris promised he would pass the Disabilities Act, whereas he promised he would work with us, and whereas he's refused to meet us, and whereas they haven't done anything, therefore we condemn the government. Well, you put in a resolution like that, the government's going to defeat it. So what's the point? So one suggestion that was given to us from within our group was, why don't you pass draft a resolution that the Mike Harris government itself can't vote against? And that's what we did. The resolution in effect said, whereas the government, I'm paraphrasing, Mike Harris government promised a Disabilities Act, therefore this House resolves that the government should pass a Disabilities Act and should work with the disability community to develop it. So the government was put in a bit of a pickle. If they vote against it, what they're really doing is saying, yes, we should break our own promise. But this was a premier who said he'd keep all his promises or resign. The strategy worked because when we got to Queen's Park and folks with disabilities came to knock on doors and try to get this resolution passed, the opposition, obviously, the Liberals and New Democrats obviously voted for it. The PCs spoke against it, but voted for it, and it passed unanimously. After that, the cabinet minister responsible had to meet us. She couldn't not. The House had just unanimously resolved they should work with us on this. But there was no real action. So what did we do? What was our next priority after this resolution passed? Well, we decided we would work on one thing, and we decided counterintuitively we would not work on another thing that you probably think we should work on. What we decided not to work on is what we want in the details of a Disabilities Act. Why shouldn't we work on that early on? Because we didn't have a government at the table that was ready to roll up its sleeves and really talk policy. So we figured for us to spend our time debating policy over how should you define disability and which enforcement procedure should you use and what should be in the act and so on, it'll gobble up our time, probably divide people within the community, and meanwhile we'll be no further ahead. We decided, no, we're going to set that one aside until there's time, we reach a time when the government was ready to really talk to us about the contents of a Disabilities Act. So instead of the thing we decided not to work on, the thing we did decide to work on was organizing people with disabilities. When we started out, we were just Toronto-based. So we decided to go community to community. This is all volunteer efforts or voluntary agencies supporting it, and to organize people. How did we do it? Put simply, here's how it worked. You go to a community, you find out who are the well-respected major individuals with folks with disabilities or organizations with good roots there. Ask them if they'll pull an event together. You don't ask them if they're going to head up some new committee or whatever. No, everybody will say, no, I'm too busy. Say, look, all I want you to do is, can you pull an event together? We'll come in and we'll give the speeches and so on. And invariably somebody's prepared to do it, and they did. And then when you get to the event really had 3 parts to it. And we did this in about 20 or more communities around the country, around the province. And they were great fun. The first thing you do is you have a welcome speech, explain the history, what we're here for, and so on. Why we need a Disabilities Act, what the government promised, why they're not talking to us, and so on. And that usually got people pretty motivated. But then the core of the meeting was the second part. We played a game called What's My Barrier? It wasn't really a game. We had everybody sit at tables, around tables. We had everybody go around the table and talk about barriers. What barriers do you face, or what barriers do people with disabilities you know face? And we had people keep a list, and we compiled this huge inventory of barriers and got ideas on what could be done about it, what should be done to fix them. By doing this, we got people thinking in terms of barriers. And this was a hugely important strategy for us. See, up until the ODA movement came along, or the Disability Act movement came along, people usually talked in terms, within the disability community, in terms of discrimination. And these barriers we face, whether it's steps to get into a bus, or lack of sign language interpretation at a hospital, or no braille on your elevator buttons. Those are contrary to the Human Rights Code. They are discriminatory in legal terms. However, the term discrimination tends to alienate some people, or get people get their backs up and so on. So we decided, why don't we just talk about barriers? Because who's in favor of barriers? Nobody likes them. Businesses think. If you go to a business and you've got barriers to customers spending money, oh no, I don't want those. Let's get rid of them. I want customers spending money on me, in my store, and so on. So the game, the activity, What's My Barrier, got people thinking in terms of barriers as touching their lives. The other reason it worked really well is because in the past, folks with disabilities had tended, not always, but quite often, to focus on their own disability. So you'd have deaf folks advocating for more sign language, or blind people advocating for more braille, or whatever it may be. And governments love that, because then they can say, well, we'd love to give you more sign language, but those blind people have demanded more braille. And they play you off against each other. But by defining our strategy in terms of barriers, by having people sitting around the table talking about what's my barrier, what have I faced, we got people thinking that what they were all facing was the same thing, barriers. Whether it's lack of sign language interpretation at a hospital, or steps to get into a bus, or whatever it may be, they're all barriers. It became the common language that united us. And it's what prevented the government from dividing us. And as our movement grew, what we found is that we were talking about each other's barriers. So you might have a deaf person before a standing committee at Queen's Park talking about why it's wrong to have steps to get into a bus. Or a blind person who could handle spoken language just fine, talking about the need for sign language. It was a form of cross-disability unity or harmony to talk in terms of barriers. The third thing we did at these events, after you got the people interested in the topic and talk about what's my barrier, you get up at the end, and I or whoever's leading it, we would get up and say, okay, would you like to join? I propose that we form a regional group for the Ontarians with Disabilities Act in your community. All in favor? It was always unanimous. And then we'd say, anybody want to help us organize? We're not going to have elections. We're not going to have big formal structure and bureaucracy. Anybody interested in helping organize, sign up. And people signed up. And then to finish the process, we always wanted, the ODA committee wanted to have a couple of people that they could use as their point people in each community. Now, if you give them a fancy title, president, chairperson, leader, everybody's going to compete for it. So we decided to come up with the untitle. We called them regional contact. Sounds like something on top of a battery. And we had absolutely no political strife in any community. Why is he the regional contact? Why am I not the regional contact? And sometimes you had two people. Sometimes somebody else would come along and say, Mift, I want to be one. Why is it them? Okay, fine, we'll have three. Who cares? 3 of you? That means more people to handle the work. And it worked. And we left each community to kind of do their own grassroots organizing. And we would liaise with these regional contacts and so on. And we went community after community, and the movement just grew. It was really exciting to see. The next, okay, so that's 1996, 1997. Let me now race through the next years, because everything I've just said is the groundwork. The problem, of course, at this as 1997 rolls around, is how do you reach out to people and how do you communicate with people, especially if you don't have any budget. You've got all these people who, what they have in common is they agree with our 11 principles, they form these regional groups. You need to be able to communicate with them. Well, thankfully, what was now starting to blossom was email and the internet. And starting really in '98, we started harnessing that power dramatically, and have been using it to this day is our way to reach out. Footnote, or pause for a moment, shameless promotion right now. If you don't get our email updates and would like to, we'd like to sign you up. Jeffrey, if you could pass around a list. We're passing around a list. If you're interested, just print, don't write, print your email address. If somebody's watching this on YouTube, you want to get our updates, just send an email request to aodafeedback@gmail.com, aodafeedback@gmail.com. Passing around the list is how we compiled more and more and more supporters. What I couldn't say back then, but I can say to you right now, before this commercial break is over, is you can also follow us on Twitter. Alas, there was no Twitter back then. At David Lepofsky, DavidLepofsky, or at AODA Alliance. That's our new coalition. Same tweets for both. Encourage you to follow us. I don't hear any smartphones coming out. I encourage you to follow us and to retweet our tweets. If you're on Facebook, we have a fan page. Please like and retweet and share our page. It's called Accessibility for Ontarians with Disabilities Act Alliance. Our tweets go out not only on Twitter, but on our Facebook page. If only we had that 20 years ago. End of commercial. Back to our regularly scheduled program. So it's 1997, 1998, we started harnessing the power of the internet. We created a website to start posting information and started sending out Ontarians with Disabilities Act Committee updates to start spreading the news. That activity, which was brand new then, has become a bedrock for our activity today. And I will tell you, happily, that the website of the Ontarians with Disabilities Act Committee, even though that coalition wound up in 2005, when the legislation was passed, we've preserved the website online as a legacy of all our work. So if you go to odacommittee.net, you can read all our updates starting back in 1998. So what's next? 1997 rolls around, you've been doing this community organizing, you got this resolution passed in 1996. What's the next phase? Well, in the summer of 1997, we started getting a glimmer of indication from the Ontario government that they might be ready to talk to us about the contents of a Disabilities Act. Just a glimmer. They said they might they started talking about holding a public consultation and so on. That triggered for us our next priority over the next year. We needed at that point to say, okay, time for us to take off to end the embargo on talking policy. We've got to start developing concrete proposals. And so we launched a year-long strategy. I don't have time in this lecture to get into the contents of the policy, but let me tell you how we reached out. We continued holding these public forums and engaging in this What's My Barrier activity. And we compiled all those barriers into a major list. We then circulated a goals paper where we asked people what their goals were for a Disabilities Act and started gathering ideas from people. And eventually, this culminated in our preparing a blueprint for the Disabilities Act, which we made public in 1998. It explained in general terms what we wanted based on our 11 principles. It made the case for it, and attached to it was an appendix called Living in a Province Full of Barriers, which actually summarized or synthesized all the barriers we'd been hearing about at these public forums. We did this so that our community could look to this blueprint and see that it reflected the very input we'd been receiving over the past 3 years. Moreover, while we had not been having a major policy discussion within the community before this, we did float ideas, and our blueprint reflected those ideas as they developed over time. Some of the input we got came from cross-disability community forums. Some was sent in by individual organizations. And one fabulous initiative was undertaken by Gary Malkowski, now no longer in the legislature, working for the Canadian Hearing Society, and Chris Kanopik, who was then president of the Ontario Association of the Deaf. They held a series of public forums around the province for the deaf community and sent in very specific proposals from their community's perspective, which were very helpful as we developed our blueprint. So we made our blueprint public in the spring of 1998 so that the government had some idea of where we were coming from. And as we put it, since the government wouldn't give us ideas of what they thought should be done, we thought we'd put out our blueprint as a discussion paper ahead of them. So that was an enormous amount of effort by a lot of people to pull that together. And it's still up on the ODA committee website. You could read it. Along comes the summer of 1998, and that starts the next phase in our activity. And as with many other phases in our activity, external events defined them for us. In the summer of 1998, the Ontario government, 3 years after taking office under Mike Harris, finally decided to announce a public consultation on a Disabilities Act. They didn't do so by a news conference, they did so by posting a discussion paper on the internet to low profile it as much as possible. We were ready. We immediately leapt on their announcement and went public with it and rallied to organize people with disabilities to take part. We had a couple of major concerns about their consultation. Their discussion paper actually, rather than being a basis for discussion, tried to foreclose discussion on a number of important points. It decided that any provisions in the Act regarding employment would be voluntary, not mandatory. There'd be no new enforcement agency. So we went public criticizing that. You don't have a consultation to find out what should be put in a law by first announcing what you refuse to put in the law. The second problem with their consultation was that it was closed and it was invitation only. They weren't going to hold public meetings. They were going to have private consultations where the minister or other government officials would invite who they wanted to hear from into a room behind closed doors. We thought that wasn't good enough. So what did we do? We swung into action again. We said that if the government wouldn't hold public hearings, we would. So on August 4th of 1998, we used two or three committee rooms at the legislature to invite people with disabilities to come in and say what they think should be in a Disabilities Act. And we invited all three political parties to send members of the legislature to sit in and participate in these hearings. In other words, we called the hearings. And we held them in the very rooms at Queen's Park where the government usually holds hearings. Well, the opposition NDP and Liberals were prepared to send MPPs, obviously, to be there because they're in the opposition. They agreed with us, and they also it had tactical advantage for them. But even, I think, one conservative MPP came, at least one, and if you were at Queen's Park that night, you would have seen what looked and sounded and tasted like public legislative hearings. Only the legislature didn't call them, the government didn't call them, we did. We also used every avenue we could to encourage people to pitch their position to the government and to propose to support our blueprint that we'd released earlier that year. So what did the government do? Or what did we do when that consultation's all over? We knew the government was going to come forward with a bill. We were worried it wasn't going to be very good. And so we decided to preempt it and to get ahead of the game by coming forward with another legislative resolution. The person who introduced this one was a Liberal backbencher opposition member from Windsor named Dwight Duncan. He was later to become Ontario's finance minister and a strong supporter of the Disabilities Act movement. He came to us offering to do something. We asked for a resolution. He said, what should be in it? We said, our 11 principles. We'd already gotten a resolution passed in 1996 saying, hey, government, will you pass a Disabilities Act? Now we were going further. We were saying, hey, government, would you pass a Disabilities Act that fulfills these principles? And we went to work again, lobbying one member of the legislature at a time and encouraging individuals to do the same across the province. October 29th, 1998 was a decisive day in our campaign for accessibility, because on October 29, 1998, Dwight Duncan formally introduced his resolution. The Liberals and NDP supported it. People with disabilities were on to watch the debate and to go door to door to campaign, even in the building, to get MPPs to show up and vote. The Mike Harris Conservatives spoke against it, but unanimously voted for it. That resolution passed unanimously. To this day, how many years later? Over 15 years later, to this day, that resolution is treated as the yardstick for measuring success or progress under disability legislation in Ontario. It was an amazingly exciting day. But we learned another very important lesson that day. And it's a surprising one, perhaps, for some of you. Right after that resolution passed, we went to the Queen's Park Media Studio to hold a news conference. And speaking at that news conference, I had the privilege of speaking as chair of the Ontarians with Disabilities Act Committee. But sitting beside me was a gentleman named Dalton McGuinty, the newly elected leader of the Liberal Party. And he said that if he is elected premier, his government will pass a law that will fulfill this resolution. We got it on videotape. It was a huge step forward for us. But what was amazing was not one single news outlet covered any of it. None. There was no coverage of the resolution, there was no coverage of the debate, there was no coverage of the vote, and there was no coverage of Dalton McGuinty's, then opposition leader Dalton McGuinty's promise to us. And yet this was the most decisive moment in years of advocacy. What was the lesson we learned? We learned that sometimes the media just miss the most important stories and just don't get upset about it. Carry on. It's very easy to get all riled up, agitated, frustrated, and hopeless when a major breakthrough happens or a major issue comes forward and you don't get media coverage. But we learned then, and have learned over and over again, that there are times we get tons of media coverage when we least expected, and there are times when we think we should get tons of it and we get none. Just carry on. That has carried us, again, for the past 15 years. Because, as I said, you look back on one of the most important days, and we got no coverage at all. And yet, that victory that day still continues to serve us very well. Well, what did the government do about it? The government voted for the resolution, but about 3 weeks later, on November 23rd, 1998, the government brought forward its first Disabilities Act that it proposed, the Ontarians with Disabilities Act 1998. It was a complete disgrace. It was only 3 pages long, including the preamble. It did not require a single barrier to be removed anywhere, ever. It was a joke. The opposition, and by the way, we didn't get any heads up it was coming. The opposition, NDP and Liberals, blasted the government over it. The media slammed it. The newspapers ran editorials against it. We got a ton of attention on it. If you go to the ODA committee website from back then, you'll see there's just a ton of media attention at this as being a slap in the face to people with disabilities. 17 days after it was introduced, as a result of our opposition to this bill, the government let it simply die on the order paper. So let me turn to 1999. You're going to wonder how, in the next 10 minutes, I'm going to get you from 1999 to 2005. But I'm going to do it. 1999 rolls around. We just continue doing our city-by-city lobbying and organizing. The government still came forward with no bill. So in November of 1999, a year after the date when the government introduced its first bill, we got the opposition to introduce a third resolution calling for the Disabilities Act to be passed within 2 years. Yet again, something the government couldn't say no to. And that resolution passed unanimously. Earlier that year, 1999, I'm a little out of sequence, there was a provincial election. This was our second provincial election in raising our issues. The first, 1995, we were tiny. This time we were much more organized. And we went out raising disability issues, non-partisan. We don't tell people who to vote for or who to vote against, but we simply talk about the records of the parties and the commitments of the parties. Both opposition parties promised a Disabilities Act in the 1999 election that complies with our 11 principles. The Conservatives promised nothing. And the Conservatives won another majority. One of the things we learned in that election was a lesson that's carried us forward dramatically as well, or a significant lesson that has informed our work later on. Believe it or not, one of the hardest times to raise a provincial political issue is during a provincial election. You would think it should be the easiest time, but it isn't, because the media and the parties are all focused on the party leaders and their platforms and who's ahead and who's behind. You come along with an issue that they're not raising, it's very hard to get attention. We did our best, but we learned not to be frustrated if you don't get a ton of attention and a ton of coverage. We decided to carry out our activities door to door at the grassroots. The government got reelected, and as I said a couple of minutes ago, sorry I was a little out of sequence, November 1999, we got the opposition to introduce and unanimously got passed a resolution that said, Disabilities Act to be passed within 2 years. We then started a countdown. 2000 rolls around, government shows no sign of doing anything. So at our suggestion, the opposition Liberals, again, we'll work with any party, but the Liberals took up this idea, decided to hold their own shadow public hearings, and they traveled to, I think, 15 cities around the province, holding public forums themselves, reiterating and expanding upon our message. This kept the momentum going. The fall of 2000, the opposition Liberals leaked to the media, they didn't get this from us, they leaked to the media that the government planned another Disabilities Act that sounded like it was only going to be slightly better than the 3-page disgrace that was offered to us in 1998. The media gave that front page coverage. We went into action saying, don't give us another weak bill. And the government backed down. 2001 rolls around, and we get our fourth cabinet minister on this file for the Mike Harris government, a gentleman named Cam Jackson. And Cam Jackson was the first minister who seemed to be ready to take this file seriously. He went out and talked to folks with disabilities in 2001 in various communities. And he put together a bill that he introduced on the 5th of November, 2001. That bill was to be passed by the end of the year and was called the Ontarians with Disabilities Act 2001. It's still the law of the province of Ontario. That law was inadequate. It didn't even remotely meet all our needs, but it was to play an important role. Let me tell you first what we did that fall to mount our campaign, and then what the law contained. What we did, once we realized we got a bill that was going to be really coming and that we were going to have to be face to face with it in the legislature, going through the 3 votes, they're called 3 readings, in the legislature, and possibly public hearings. The first thing we realized is that we needed to educate our community on how a bill gets through the legislature. Most people don't know this. So we released a short guide, step by step, to explain what's first reading, what's second reading, what's a private member's bill, what are amendments, what are hearings, what's clause by clause debate, and so on. And the second thing we did is, before the bill was introduced, we released a checklist. Here's what to look for in the bill. If it meets these requirements, it's good. If it doesn't, it's not. So the two tools we gave our community, and now we're using the email and the internet to spread the word because it's 2001 and reaching a lot of people, would equip them to understand both how the process works and what to look for. November 5th, the government introduces a bill, and that bill was run through the legislature in a mere 6 weeks. First reading, second reading, public hearings, third reading. Unbelievably fast. We had to be ready. It was an amazingly trying time. What we did was we analyzed the bill, released our concerns about it, which were many, proposed amendments, and released a brief so that our community could learn what our concerns were and could go and raise them, if they agreed with them, before the Standing Committee of the Legislature. So what did the bill say and what were our concerns? The bill said that any organization in the public sector, meaning the provincial government, municipalities, colleges, universities, school boards, public transit, hospitals, every year they would have to make an accessibility plan and make it public. And it also said that any city with 10,000 people or more had to have a Disability Accessibility Advisory Committee. So what was our problem with it? Well, for one thing, this bill would not require a single barrier to be removed, ever. Nothing, ever. And the second problem was that it only applied to the public sector, not the private sector. It didn't address barriers in stores or in a doctor's office or a lawyer's office, or all sorts of important things, places we might want to go, but which are not in the public sector. It did provide for accessibility plans made by an organization like this university, but it didn't require them to be any good. They could have an accessibility plan that was 3 sentences long. We have a curb out front. We'll put in a piece of wood on it. Done. You obey the law. Moreover, the law didn't require an organization that has an accessibility plan to actually fulfill what they put in their accessibility plan, ever. It was great that it provided for each municipality with 10,000 people or more to have a Disability Accessibility Advisory Committee, but it didn't require the municipality to ever listen to a word they say, or if they disagree with them or their advice, to ever give them reasons for not following their recommendations. So we said, this is just way too weak. So we put forward proposals to make accessibility plans stronger, to make them mandatory, to make them enforceable, and to extend this beyond the public sector, to provide for enforcement and so on. The bill had other requirements. It allowed the government to create accessibility standards to detail what organizations need to do, but it didn't require the government ever to make an accessibility standard under that power. So what happened? It was a fabulous experience in one way and a frustrating one in another way. The fabulous part was that individuals with disabilities and disability organizations from around this province came forward and made presentations at these public hearings. Their presentations are fabulous. They're up on the ODA committee website, and you can read them. They're great. They read, studied our proposals, borrowed some of them, rejected others, came up with their own, and offered rich, diverse, and good ideas. That's the good news. The frustrating news is that the government didn't listen to virtually a word we said. And ultimately, they made a few tinkering amendments, and then they rammed the bill through. Last law that was passed under Mike Harris's leadership, before he stepped down as Premier, was the Ontarians with Disabilities Act 2001. Let me take you from 2001 to 2001 to 2005 in literally 3 minutes. From 2001 to 2003, we pressed the government to effectively implement their weak bill, and they did very little. 2003, there was a new provincial election. We urged all the parties to commit to a stronger Disabilities Act that complied with our 11 principles. The NDP agreed, the Liberals agreed, the Conservatives did not. And in October of 2003, Dalton McGuinty was elected Ontario's Liberal Premier. From 2003 to 2005, we didn't have to engage in the kind of grassroots advocacy that I've been talking about for the past hour to work with the McGuinty Liberals. Because when they took power, they made it clear from the beginning that they meant business. And they assigned a new minister, a minister to handle the file named Marie Butriani, who sat down and got active very quickly on this issue. She held public consultations around the province with people with disabilities, with business and others. She came forward with a bill within a year, 2004, which, while not everything we wanted, was a substantial improvement. She held meetings with the community, and her staff did, to hear what their concerns were about the bill. They had televised public hearings around the province on the bill. We came forward with proposals for how to strengthen it, and while not all of our proposals were taken by far, a number were. And the bill was passed in 2005, on May 10th of 2005. In a nutshell, the bill was a substantial improvement over the Ontarians with Disabilities Act 2001. It applied to the public and private sectors. It requires Ontario to become fully accessible by 2025. It requires the government to create, enact, and enforce accessibility standards. Indeed, all the accessibility standards needed to get to the goal of full accessibility by 2025. And it has a series of powers for enforcement. The day it passed, two miracles happened. On the floor of the legislature, all three parties voted for it, and all three applauded it with a standing ovation. That does not happen at Queen's Park very often. And second, right after it passed, in the Queen's Park Media Studio, speaking in support of the bill at a press conference, for the government, Dr. Butriani, no surprise, from the disability perspective, me for the Ontarians with Disabilities Act Committee, and a representative of the Retail Council of Canada. To have Liberal, Conservative, and NDP, disability community government, and business voices united at the same time and place was quite an accomplishment, and it was something that those of us a decade earlier, the 20 of us in that room that I talked about earlier, would not have foreseen. Let me conclude by telling you about a fortune cookie. I want to summarize everything I've told you about, leading up to the enactment of this legislation, with a fortune cookie. The day, May 10th, the day the law was going to pass, and we knew it was going to pass that day, I went to lunch with a friend, and we went to a Chinese restaurant. They brought us fortune cookies at the end. I regret the fortune was not in Braille. I would need a fortune cake, not a fortune cookie, to fit a Braille fortune in it. But I opened the cookie, ate it quickly, and passed the fortune over to a friend of mine. The words on that fortune summarize the 10 years advocacy by the Disability Committee that I've had the privilege of serving. Those 10 years of work summarized in the words on that fortune, which were simply this: every great accomplishment is at first impossible. What we set out to do back in November of 1994 was by any measure impossible. But with the efforts of individuals from around the province, Liberals, Conservatives, NDP, young and old, men and women, every kind of disability or no disability, we were able to accomplish the passage of this legislation. Now, it's for later lectures for me to talk about, that I'll be doing at Osgoode Hall, and to which you're invited, talk about what's happened since 2005, why we're disappointed that we aren't further ahead, and what we're trying to do to make it better. To learn more about our activities, you can visit the website of the Ontarians with Disabilities Act Committee, wound up in the summer of 2005, because it existed to get these laws passed. A new coalition took over its function, called the Accessibility for Ontarians with Disabilities Act. The law that was passed in 2005, Liberals called it the Accessibility for Ontarians with Disabilities Act, or AODA. The new coalition that took over became known as the AODA Alliance. To learn more about it, you can email at aodafeedback@gmail.com or visit www.aodaalliance.org. But I conclude with the words of that fortune cookie. Every great accomplishment is at first impossible. Thank you very much.